Okay, a couple of things about assignments and tests and stuff. I'm going to accept the blame for it, but I didn't give good deadlines, all right? And so I'm still getting practice test 2s and 3s and on the brewery and from the 210 class on the volleyball. I mean, they're just kind of coming in. You know, I got 3 last night at midnight. So from now on, when I give you something, we're going to have a deadline, and it has to be done by then to turn in whatever you've done. If you can't finish it, just turn in what you've done, because it's just for practice anyway. The other is, even though I sent you the pep talk email at the beginning of the week that everybody was doing great, what everybody's doing great is participating in the class. Class participation, straight A's, all right? Everybody's coming. We're having a few absentees, except today. Everybody's participating. When you're giving me something on a practice test, it's obvious that you're thinking about it. I mean, you're not giving me just junk. I mean, I'm getting good thoughts. The thoughts are not in the order of what you need to be doing to get a good grade. So this weekend, I'm going to take one of the practice tests. I'm going to take one of the fact situations, and I'm going to do an answer in the AP style, and I'll email that to you on Monday, and then we'll go over it on Monday, and you can compare what you're doing with what I want. Okay? And I've had to do that a couple of times. I don't mind doing it. You can't then copy mine on the next ones. I'll still want your individual touch to it, but I can give you a better idea of what an A+ paper would look like and what I'm expecting you to get, all right? Now, forms of business. What do we do next? Come on, everybody already have cheat sheet. What do we do next?
Basic business equation.
All right. Basic equation, then what? Ethics. Management. Today we are going to do in one day what you kind of do the whole semester of 210. We're going to do contracts, torts, and criminal. I'll be brutally honest with you. I don't think I would test a 101 class on those 3 things, on the contracts, on the criminal, on the torts, but I might throw a contract test in the contract issue. So let's talk about these 3 things. Anybody got a question about the first 4? Everybody okay with those? All right. The YouTube videos, one of them is up. I just got 2 more. I'll put those up today, and from now on it'll be a couple, every week. All right, contract. 2 or more people or business agree to mutual promises. That's the basic of a contract. 2 people agree to do something. All right? I agree to teach you, you agree to listen. You pay tuition in Newberry College, they agree to provide you with classes. It's mutual exchange of promises. Now, you might remember what I said the word express meant? We've talked about express. Anytime you use the word express in law, it means written. So you can have a partnership on a handshake, but if you write it down on a general partnership agreement, it becomes an express partnership. If you don't write it down, maybe it can be an implied partnership, and you'll see that in 210. An implied contract, the letter K is used by all business and all legal people for contract. So if you see me use the letter K, that means contract. And you're welcome to use that in your answers. And there are 2 or 3 other abbreviations that you'll get to later in the semester. So an implied contract is one that's not written, but still has mutual promises. Now, my wife and I have since sold our house, but when we had a house downtown, there was a guy across the street that I asked him 4 or 5 years ago if he would cut my grass. And he said, sure. So he would cut my grass, and I paid him $20. A couple of weeks later, I asked him again. He cut my grass. I paid him $20. We did that all summer. It then got to the point, he did it for 4 years. It got to the point where if the grass needed to be cut, he would cut it. And then I would see him in church, or I would see him in the yard, and I would say, hey, how much do I owe you? And he said $40. I've done it twice, and I'd pay the 40. And every now and then he would knock on the door, I need to get some money. But say if he did it 3 times in a row, and he came and knocked on the door and said, Mr. Leon, I need $60, and I've cut your grass 3 times, and I said, I've decided not to pay you. We have no contract. We don't have anything written down. Would that be fair? No. And so the law puts into effect issues that make it fair. And one of the things they put into effect is what's called an implied contract. Right? An express contract would be in writing. An implied contract is by the actions of the parties. Him cutting the grass, me paying him, is enough to imply that that's a contract, that that's a mutual agreement between us, mutual promises. Now there's 3 things that you have to have for a contract, whether it's written or whether it's implied. First is an offer. You have to have an offer. Believe it or not, that sometimes is an issue. Okay, that's sometimes an issue. If I offer, if Corporation A has been buying trucks from Corporation B, and they've bought 10 trucks last year, but this year hasn't even mentioned it, and Corporation B sends the 10 trucks, well, that's not enough for an implied contract. They've only done it once. And they weren't asked, so there was no offer that I'll pay for it. So an offer has to be mutual promises. Secondly, which makes sense, there has to be an acceptance. I offer to buy 10 trucks from you. I accept that. I will send you the 10 trucks. And here's where it gets a little sticky, because the third is consideration, which is value. It has to be something past. Normally, 99% of the time, that's going to be money. But it may be a bartered situation, or it may be something other than money. But you have to have an offer, you have to have an acceptance, and you have to have consideration that is paid. So jumping ahead to an exam, if I wanted to slip in a contract question, and I've had you form a business, and you've you've got a management team, and you've chosen SWOT and strategic management, and then I tell you that your business has offered to buy 10 trucks, and the other, Corporation B has sent you 10 trucks, discuss these issues. All right? You would have to tell me this is a form of business issue, this is a management issue, this is a contracts issue, and there is no consideration. The contract has to have offer, acceptance, and consideration. You cannot assume a fact in the test, so you can't assume they were paid. So you might have offer and acceptance, but if there's not any fact of consideration, then there isn't any contract. Now, contracts are either valid, which means they're good, offer, acceptance, and consideration, or a contract is void, which means it doesn't have one of the three. And you would say that it's void. You don't say it's a bad contract, or you don't say there's no contract. You say it's void. Use the proper language. If there is a valid contract, and then somebody doesn't pay or doesn't finish it, you pay for a construction and they only build half the house, then the contract is what's called breached. It's commonly, you'll hear somebody say, well, they broke the contract. The proper language is they breached the contract. You know, you just, if you're going to go to college, you might as well learn the right words. All right, that's contract law in a nutshell. We spent a week or two in 210 on that. Does anybody got any questions about that? Everybody understand offer, acceptance, and consideration? Have to have all three. Can't just have two. And if I give you a contracts question, I expect you to recognize that there's an offer and acceptance, so this is a contract issue. And then tell me, contracts need offer and acceptance, and Mary and Beth have an offer, or Mary and Beth have accepted, and consideration has been paid, so this contract is valid. 2 or 3 sentences bumps your grade way up. Remember, I can give you a really good test that's got 2 or 3 or 4 of these on there, and it may have a contract on there, and what I'm testing you, remember I tell you over and over, is whether you recognize it. Okay, whether you recognize it. And if you recognize that this is a contracts issue, this is also a contracts issue, if you put that in the test, I'm not really worried whether you get offer, acceptance, and consideration right. You know, I'm more worried about you recognize the contract. Let me enforce that a little bit. In one of the 210 classes, and I won't say which one of the students, and I won't say which one, all right, I gave a practice test, and you know, they choose, in 210, you choose between partnership, limited partnership, corporation, or LLC. So you got 4 possibilities. So one of the students to the practice test gave me a 3-page, single-spaced answer. Gave me a 3-page, single-spaced answer on how it should be a subchapter S, section A, 102B, or something. All right, I mean, they had taken it upon themselves to look up something we hadn't studied and look up the law or look up Wikipedia and give me this long, involved answer of what these people in the test, in the fact situation, should have done. All right? And I didn't give that person a good grade, and they asked me about it, and I said, here's the situation, okay? When you graduate, and you have to decide to write an LLC. You have to form an LLC. And your boss says, I want you to form an LLC. Or you go to practice, you go into business by yourself and you want it to be an LLC, limited liability corporation. Or you want it to be a corporation. 4 years from now, I don't know what the laws of corporation are going to be, but they'll be different than they are now. So when you sit down to form a corporation, you are going to have to look up the forms from the Secretary of State's office, and you're going to have to fill out those forms. Why should I teach you to do that today? That's what other business professors do. I want you to fill out this corporation. That's nothing. That's filling out the forms. But teaching you that you need a corporation instead of an LLC, or that you need a partnership instead of a corporation, is a different question altogether. All right? So I had to tell this student, I want you to know, I wanted you to tell me why you chose one of the two. Don't give me 3 pages on why you chose a 4th. That's not the purpose of the class. All right, any questions about contracts? All right. Contracts end up in court a lot. If you hear me say the word litigation, that means lawsuit. Breached contracts end up as being lawsuits a lot, and 210 will go all the way through a lawsuit. But the other thing that ends up as being is something that's called a tort. Now, you have probably never heard that word. It's not on TV. It's not in movies. But 99% of lawsuits of what you see on TV and movies are torts. They just don't call it that. Right? Torts are anything that's not a crime. So a tort is a injury to a person or business the main one is negligence. Negligence. Car wrecks, slip and falls. Okay. If the stadium over here, when we come first home game next year, and everybody gets in the stands and the stands fall down, all right, that's negligence because somebody didn't tighten all the bolts. So it can be something as simple as falling or something simple as a building falling down. If you go into Food Lion and you slip on a rotten tomato on the floor, or you slip on a banana on the floor, and you fall down and bust your head open, that's a tort. Because in negligence, somebody has a duty to the public or a business that results in an injury. The duty is breached. The rotten tomatoes left on the floor, and so the duty to the public or the business is not followed through, so it results in an injury. Now, there are a couple of other things to this. The duty must be reasonable. The duty must be reasonable. The old lady that falls on the banana and breaks her hip and cracks her head, right? The bag boy goes out to the parking lot, and her husband's sitting in the car waiting on her, and the old man's sitting there just waiting on his wife, and the bag boy knocks on the window and says, "Hey, your wife just broke her hip and busted her head." And the old man has a heart attack. Now, is that Food Line's fault? No, because it's not reasonable. It's a shame, it's a tragedy, but it's not a reasonable expectation that Food Line is going to take care of everybody that's sitting in the parking lot in the cars. The injury must be foreseeable. Must be foreseeable. Okay. The old man in the car is not foreseeable. In law school, we learned what's called the eggshell skull. Some people have eggshell skulls. That means that literally their skull, the bone, is thinner, and every time they get hit in the head, they have a concussion or their brain injury or they die. All right? And if somebody falls in Food Line and they have an eggshell skull, the ramifications are death. And Food Line is still held liable because they were negligent. The extent of the injury doesn't matter. But if they fell down and they're pushing a cart, and when they fell down, they pushed the cart and it ran into a little kid and hurt the little kid, it's not foreseeable that somebody that would fall would push a cart that hurts a second person. So the injury has to be foreseeable and the duty has to be reasonable. Don't bring that in here anymore, okay, please. All right, any question on torts? Injury to society. A tort is an injury to a person. A crime is an injury to society. There are some acts that are both a crime and a tort. Not many, but some. Okay? And they could, somebody could sue for damages and call the police in order to charge somebody with a crime. Okay? Stand up, Edwin. All right, now, if I tell Edwin, okay, I am going to beat your ass. All right? Now, that's an assault. That's assault. If I take my finger and I poke him in the chest, that's battery. That's assault and battery. Assault is the language, the battery is the touching. Now, he can call the police, he can call campus security, and they can charge me with assault and battery. Okay? And he then can go home and get a lawyer, and he can sue me for assault and battery for the damage that I did to him, the $1 million that I did to him for bringing him up there. Okay?
It's on recording too.
Yeah, it's on recording, yeah. Right. So,
Yes, sir. Thank you. Sure.
so there's some things that can be torts and crimes, but not many. Most crimes are an injury to society. Crimes are statutory, which means they are written. say when I was your age and I was clerking for a lawyer in the law office, and he had a case in Charlotte. And he said, Leon, I want you to find me a copy of the North Carolina DUI law. Well, I would have to go to the law school library, which is bigger than this building, and I would have to find the floor that has North Carolina, and it would be a line of books that would be stretched across this stage, and I would have to find the book that had the DUI law in it, and it might be under alcohol, it might be under driving, it might be under underage, it could be, but I've got to find it. And so when I find that North Carolina DUI law, it's on a piece of paper, right? And that's a statute, that's a law. Now you can do all of that before I finish talking on your phone, but I couldn't when I was your age. Right? But even whether it's on the internet or whether you have it in your hand, it's a written down law. Now South Carolina has what's called solicitors. That's a district attorney. We are the only state that call them solicitors. All other states call them district attorneys. TV and movies call them district attorneys. In South Carolina, they're called solicitors because we are one of the oldest English colonies, and that's what they call them in England, so they just have always called them solicitors in South Carolina. On the other side, you have the defense attorneys, which is what I was, and they represent the defendant. Another little symbol, the delta symbol, represents the defendant, somebody charged with a crime or somebody that has committed a tort. If you see that delta symbol. So, in order to commit the crime, the defendant has mens rea or actus rea. That is motive. You don't ever hear those words on TV, but you hear motive and that kind of thing. What mens rea means is Latin for mental intent. Mental intent. So mens rea is intent. You have intent to kill somebody. Actus rea is you don't have intent to kill somebody, but you're waving around a loaded gun in a mall and it goes off and somebody's killed. It's the same effect. All right? So mens rea is intent. Actus rea is a crime is committed by the intent, by the acts of the party. They then are charged with the crime and assigned a district defense attorney, and the solicitor takes them to court. And in business law, you'll have 2 weeks of that, all the warrants and all the constitutional effects and all of that. But I want you to know that it is part of business law. Okay? It is part of business law. It's not murder. Extortion, embezzlement, fraud, white-collar crime is a big deal. A big deal. And they're usually done by unusual people. Embezzlement is usually done by the person, the secretary, or the lowest ranked accountant in the accounting department whose job is to cut the paychecks. And the paychecks are $500 a week for 100 employees. But every check he cuts, or she cuts, is $4.99. And nobody worries. And somebody comes in a couple of years later and says, how come my check's $4.99 instead of $500? And they say, oh, that's taxes, or that's health insurance. And nobody worries. And they put that penny in their own account. So the first week, they're putting in 100 pennies. Well, they do that for 100 employees for 30 years. And it earns interest, and then somebody finally runs an audit, and they find out that it's worth, $300,000 that's sitting in some account in the Bahamas that's been stolen a penny at a time. And that's how embezzlement happens, because of the power of money. Most business crimes are not somebody steals $10 million. Okay. Those are usually not business crimes. Those are criminals. Those are people that rob banks. Business crimes are stock fraud or embezzlement, where it starts out little and it lasts a long time, and it just builds up. And people don't realize how much trouble they're getting into. If I ask Sander, would you play golf against me, and I will bet you 1 penny on the first hole, and we will double the bet every hole for 18 holes. Would you do that?
Yes.
All right. You know how much number 18 would be worth? I think it's $82,000. Okay, that's how fast, when you start doubling the money, how fast it adds up. And I wouldn't play you for $82,000. I wouldn't play her for $82,000. All right. Any question about crime as it relates to business? Contracts, offer, acceptance, consideration, torts, duty, injury, foreseeable duty, foreseeable injury, reasonable duty, and then crime, statutory, written, mens rea and actus rea, and injury to society. Any questions about that? Any questions about how that would be worked into a test? Would you be able to recognize that if I gave you a paragraph that had a bunch of facts in it? Do you think that you would be able to recognize this is a crime, or this is a tort, and this is management? This, that's what you got to do. Think so? Okay. Yep.
So, when we're writing it, do you want us to put down like mens rea and actus rea, or do you want us to put in like they intended to do this and they acted upon it by doing this?
That's a good question. I would take either. Yeah, I would take either. But that's the kind of answers that I'm getting. Okay, as long as you show me that you're thinking about it and you thought about intent, you're going to get credit for it. But if you leave it out, then I don't know whether you thought about it or not. All right, we've got a few minutes. The other class wanted a couple of war stories. Y'all want to go, or you want war stories? All right. The first we talked about was beyond a reasonable doubt for an attorney, for the solicitor to prove a crime. And TV is wrong when they say guilty or not guilty. It's proven or not proven. You prove it beyond a reasonable doubt. Right? So I had a guy that was charged with burglary, first offense, and it was a third strike, so he was looking at life in prison. You can go to him. Life in prison. And an old woman woke up, and he was standing at the foot of her bed. And she was scared. She screamed. He jumped out of the window. The police come. She cannot identify him. And the only thing they could find was a bunch of stuff on her dresser, including a Hallmark card that had his fingerprint on it. And footprints where he had jumped out of the window into the mud. All they had. And he's looking at life. So I was appointed to represent him, and I called Hallmark in that town, and they said, we got 10,000 cards in our store. I called Walmart, and they said, we sell those fake Nikes. We got 5,000 of them, most of them size 10. And so when the policeman took the stand, I said, did you know that Walmart sells 5,000 of these same shoes every summer? And he said, no, I didn't know that. That's all I asked him. The sled agent, fingerprint guy, took a stand, and I said, did you know that Hallmark here in town has 10,000 cards? And the sled agent said, that doesn't surprise me. I said, would you agree with me that everybody that goes in looking for a card touches the cards as they're looking for the one that they want? And he said, yes, they do. And I said, if you went into Hallmark, would you find fingerprints of everybody that had been in that store that had touched those cards? He said, yes, I would. And the jury came back not proven and let it go. Came back not guilty. Because it's got to be beyond a reasonable doubt. Even though he was facing, even though they found him in the room. Now, one that goes the other way is when someone is charged with conspiracy, it's everybody. It's like everybody on this front row is charged with a crime. And there were two Mexicans that brought 200-pound bales of marijuana from Mexico to Dallas, like a hay bale of marijuana. And they put them in cardboard boxes and shipped them on United Airlines to Charlotte, just like you would your luggage. And then they had two other people meet the airplane in Charlotte and take the marijuana off in the boxes and bring it to South Carolina, to Chester, South Carolina. Anybody live in Chester? And they had 5 people that were going to distribute the marijuana over a 5-county area. We got the 2 Mexicans, got the 5 people that are going to distribute over the 2-county area. They went to a guy in Chester, just a redneck that owned a junkyard, and said, can we keep the marijuana in your junkyard? And he said, no. And they came back the next week, can we keep the marijuana in your junkyard? And he said, no. And they said, we'll give you some of the marijuana. And he said, yes. And so they had found an old Trans Am at the back of the junkyard. They put the 2 bales of marijuana in the trunk of the old Trans Am. They cut the fence so you could get in and out. Redneck never knew when they came and went, but over a 5-month period, they distributed the marijuana in a 5-county area. They then arrested the 2 Mexicans, arrested the 5 people that were distributing the marijuana, and arrested the guy that had the junkyard. And the judge called and asked me to represent him and said, I know he wasn't a big deal in the crime, but he's charged in the conspiracy. So his charge is the same as the Mexicans. It's trafficking in marijuana, which is a 25-year sentence. Trafficking is 100 pounds or more. So the judge called me to his chambers and said, look, if your guy will plead guilty, I'll give, the carries 25 years. So if your guy pleads guilty, I'll give him 8, he'll do 4. And my guy said, oh, no, I'm not going to do it. I'm not going to snitch. I'm not going to say anything. So SLED then charged him with the marijuana that they gave him for letting them put it there, which was just a bag. Charged him with simple possession of marijuana and said, we'll drop this if you tell us about everybody else. And he said, no, I'm not going to be a snitch. So he pled guilty to simple possession and served 30 days. So now the big trial comes up, and the judge calls me and says, I'll give him the same deal. And he said, no, it's double jeopardy. I've already pled to marijuana, so they can't charge me for the trafficking. And I said, it's 2 different things. Okay, it's apples and oranges, like I told y'all. All right? Possession of marijuana and trafficking in marijuana don't have anything to do with each other. It just happens to be marijuana. So we went to trial. He turned it down. We went to trial. Midway through the trial, the judge calls me to his office and says, it's not going well. I'll offer him the same deal. He won't take it. So we go through the full trial. At the end of the trial, the judge calls me back and says, I feel sorry for this guy. I will offer him the full deal because it's looking terrible for the other 7. And he said, no, I'm not going to do it. So I make the motion for double jeopardy. The judge denies it in about 30 seconds, and it goes to the jury, and my client's now doing 25 years. He's still in jail. So, sometimes people walk, and sometimes people go to jail for a long time. A lot of it just depends on what happens in court.